Hello, everyone, and welcome to Keys to Real Estate. I'm your host, Mary Schuster. Well, everybody, we've had a big Supreme Court opinion come down in the past few days, one that has real potential to shape how we work and much of what we do. And actually, it's a big enough impact that it's going to take everyone a bit more time to sort all the way through the permutations of what exactly will translate in practice. But I think it's safe to say that the next decade of regulations and regulatory enforcement in our industry will be impacted by last week's ruling in the Loper Bright and Relentless Inc. cases. Now, there's going to be a lot of time for sorting out over the coming weeks, months, and years exactly what it's going to mean. We know that it's going to be a big change. But for today, we thought it best to understand the situation as it currently stands. We wanted to offer a table setting to help orient you to what specifically has changed so you can begin to think about the potential changes that lie ahead for your operations. Now, my guest today is a person you'll want to get to know better through this process. Elizabeth Childers is here. She's the editor of RESPA News and has been following this case closely. And she's the best person to have this first conversation with. So please enjoy my conversation covering what has changed and what it might all mean for you with RESPA News editor, Elizabeth Childers. The presenting sponsor of the Keys to Real Estate podcast is RamQuest. RamQuest fosters a customer-first culture built around an unwavering commitment to provide solutions that don't just meet, but exceed expectations. RamQuest's newest title and settlement production solution, Horizon, delivers unparalleled efficiency, robust features, and scalability to ensure you have tools to boost productivity and elevate performance like never before. Horizon streamlines your operation with secure 24/7 access, automatic updates, and all the power that only the cloud can offer. Plus, Horizon offers a direct connection to the industry's most extensive network of service providers and partners. Experience Horizon for yourself when you visit ramquest.com. And now, please enjoy the show. Elizabeth Childers, welcome to Keys to Real Estate. We're so happy you're here.
Hi, Mary. I'm glad to be here. I'm really excited about today's discussion.
Well, we have a lot to cover because we have an opinion. Chevron and the deference has been overruled. And so I wanted to ask you, first and foremost, you've been following this case for over a year. You've kind of been down in the weeds with it. You were in Washington, D.C. for the oral arguments for these two cases with Relentless Inc. and Loper Bright. When the opinion came down on Friday, what was your first reaction?
Well, my first reaction, I probably said some words that we can't record, but it was kind of this mix of surprised and not surprised. Doing my coverage leading up to going to those oral arguments, going over the cases and where they stood when they were petitioning and speaking to experts, everybody was saying, Chevron's going to be overturned. Chevron's dead. They haven't referred to it since 2016, et cetera, et cetera. But then as you and I were sitting in the oral arguments, it seemed to have a very different feel.
It did.
The more conservative judges, as we would like to say, were asking some really hard-hitting questions and were very critical of the challengers' arguments. So I was really kind of expecting not necessarily a whole overturn, maybe just a restriction or a limit, because I could concede the point when we have one judge who says there's ambiguity all the time versus another judge who says there's never ambiguity. There's potentially an issue there that indicates we need to change some things. But the fact that they completely overturned it was a little surprising.
Yeah, I agree. I had the same reaction because I was with you a year ago and reading the tea leaves that were on the ground then, I said, oh, they're going to overturn it completely. Then, yeah, when we were in the courtroom itself, it sounded like, it might just be more of a tapering, a little pullback of it. So I would say I had the same reaction last Friday. I was shocked, but not surprised. But it's going to mean a busier, I don't know, next several weeks, months, and maybe years than we had expected with a tailoring of it. So for folks that haven't been reading along with your coverage, who haven't been following along and might not know what this is about or why it's so important, let's just give a brief table setting, if you would, of what Chevron means with regard to financial services and regulation that are in, just kind of get people up to speed who haven't been following along.
Sure. So what Chevron deference is, it's a canon of judicial interpretation for the Administrative Procedure Act. The Administrative Procedure Act, I like to joke, when I was in law school, I had a professor literally say, "You're never going to have to deal with this act and this stuff when you practice law." Well, joke's on them. But it is kind of a foundation to how our agencies interact and do their job, how they interact with the industry and how the industry is able to communicate back. When you're trying to legislate literally everything these days, it's hard to keep track. So what Chevron did is in 1984, so it's been 40 years, the court said, in the event that the congressional intent is ambiguous, meaning either the Congress intentionally left it up to the agency or there's an unintentional gap in the rulemaking, that the court will then defer to the agency's interpretation of the statute they're enforcing, so long as it's reasonable. And I feel like that phrase is very, very important, so long as it's reasonable. Mm-hmm. And since then, it's been one of the most quoted opinions for judicial interpretation. And it's been relied upon by industry and regulators alike when they're doing rulemaking proceedings, when they're bringing enforcement actions. And that's where it comes into our sector and why we need to start paying attention to it, because our industry is a regulated industry. We have the CFPB, Federal Housing Finance Agency, HUD, insurance commissions, who we have to interact with and respond with all the time. And this kind of turns it on its head. That is the big point now. Now, what I found it very interesting is that we have been constantly saying it's 40 years. It's 40 years that this precedent has stood.
Reliance, yeah.
Yes, there's that reliance factor, but there's also that consideration that it stood for 40 years. If Congress didn't like the way, sorry, I'm getting a little into my own opinion here.
That's okay.
If Congress didn't like the way courts were using Chevron deference, they could have gone in at any time and changed the APA to say, no, Chevron's not part of this. And they haven't. Now, it could be that they're preoccupied with a lot of other things. Heaven knows that there's a lot of stuff going on in our legislature right now. But it also could be one of those silences approval.
Well, yes. And going back to our experience in the oral arguments, the government was saying, listen, Congress has been legislating for 40 years with this running in the background. Congress has relied on it. Business has relied on it. And while certainly when you talk to the regulated, one of the frustrations that they express is that, well, it changes so wildly administration to administration. What's enforced, what isn't. More focus is placed on, and to your point about reasonability, well, reasonable to one can look really unreasonable to somebody else. And so there's been some complaint about how malleable our regulatory enforcement can be administration to administration, and how that's hard for business to sort of pitch your sail to the wind when it's changing, say, every 4 years. The optimistic view of this, that it won't be any longer administrations having different interpretations and having those swings in the play of the joints. So what will happen now? It will, when there's a question in one of the agencies or one of the regulated has an issue, how's it going to be different go forward?
Well, not to give the lawyer answer of it depends, because I can't even say it depends, because that implies I have different ideas or different opinions of what that might look like. One of the double-edged swords of our system is that we move slowly. On the one hand, it keeps us from making impulsive decisions. On the other hand, it's hard to sometimes see how things are going to play out in a reasonable amount of time. One of the arguments the challengers made is that Chevron has been restricted and changed and altered so many times, and it's because it's not a good precedent. Well, it's an experiment, just like our democratic republic is an experiment. It didn't work, and now we need to take the time to figure out a different avenue. I hope it doesn't take another 40 years to kind of come up with a solution, but it is definitely going to be, we need to see how it's being processed now, and it's going to be a very slow going, because the courts need to have time to process. The courts need to have time to figure out how it plugged into their job interpreting.
Well, and that key change, right, is that now the agency itself, or Bureau, if you will have much less latitude, and now the court has a much greater role. So when you think about that balance of power in the triangle, the courts now have a much greater role. And so there are pluses and minuses to that, I'm sure, but that's where it's at now. So we're going to see a lot more battled out in the courts than we did before. And there's kind of two schools of thought right now. One school of thought, and I think, spoiler alert, I think they both might be actually correct. But one school of thought says, oh, this is going to really quell the number of new regulations and proposed regulations that we'll see coming out, and probably fewer enforcement actions. And there's another school that says, oh, our courts are going to be flooded, not tomorrow, but probably pretty soon. And now we're going to fight over definitions of things we've taken for granted for a while in the courts and in different circuits, and things are going to get kind of crazy. So I'd like to kind of talk about that potential terrain with you for a little bit, because it seemed like we've got two buckets. We've got the new regulations and enforcement going forward, and then we've got this second group that, even though the Chief Justice in his majority opinion said, listen, stare decisis stands for the cases that decided under the Chevron framework, stare decisis and reliance stands. Our intention is to leave those alone and have a new path going forward. But I'm not sure that's going to be the case. So I'd love to hear your thoughts about kind of all of that I just threw at you.
Right. So I definitely agree with you there, Mary. Even though Chief Justice Roberts did say, stare decisis, these past decisions stand, which makes total sense. One of the canons of statutory construction, is a presumption against retroactivity. Unless it is specifically stated that this applies retroactively, we assume that things are forward-looking, which just keeps the precedents a little holy, it's a little more stable. The good news here is the Supreme Court didn't say that courts can't look at what the agency is saying. They don't have to throw that out the window. Basically, the agency has to put the money where their mouth is. They don't enjoy that deference anymore. They have to make their argument. They have to come to fight. And again, double-edged sword. I can see where that can make them very hesitant to engage in certain rulemaking. They might be a little less aggressive and a little less creative with their reasonings behind things. But there's other canons of constructions. There's other regulatory interpretive rules that we have that they can still rely on. We saw that with the court themselves. The court has stopped relying on Chevron, which is a good indicator to agencies and industry that they should probably start looking at other canons as well. On the flip side of that, saying your other point that it's going to start flooding the courts is, I definitely have that concern. We're going to see a lot more challenges. And even if the challenges are to those decisions that have been grandfathered in, so to speak, the courts still have to take the time to look at it and interpret it, which just continues to slow down a system that's already kind of getting overloaded, especially as the industry keeps challenging, as they should. I'm not saying that it's bad. Agencies should be challenged when they make rules, especially when the industry feels like they weren't heard during the rulemaking process, or the rulemaking process didn't happen appropriately. That's the reason why it's there. Mm-hmm. But I do have this kind of slow anxiety that there might be some aggressive attorneys who might end up gumming up the works.
The opportunity's there, I think, for sure.
Definitely opens the door. Who's this? And people might not walk through it.
They might not.
We're going to be very busy. Yeah. Everybody's going to be very busy. So they might just not want to touch those, because we have a lot of rules that are being considered right now that are probably going to have a much more immediate impact to our industry than the Chevron ruling is going to. But it's still important to keep in mind as you're commenting and as you're reading these rules that are coming out.
Yes. Support for today's episode of Keys to Real Estate is provided by Rhino. Much like Monopoly, every move counts, and handling escrow accounts without the right tools is like getting to Boardwalk without a strategy. The stakes are high, and the risks are real. So bank on absolute financial protection with the Rhino software bundle. Rhino integrates with escrow accounting software and online banking systems to provide the industry's gold standard in escrow and financial security software solutions. Rhino offers continuous end-to-end accounting auditing, daily reconciliation, transaction monitoring, anti-fraud algorithms, and built-in automated reporting. Schedule a test drive today. So I know you started reaching out to your contacts immediately on Friday.
Oh, yeah.
What are the experts telling us? And again, it's so early on, you guys, and I need to actually put a timestamp on this. So we're recording on Wednesday, July 3rd. This ruling, for those of you that aren't familiar, this opinion was released last Friday, June 28th. We don't know when people are going to be listening to us. And so we are comparatively minutes out from this ruling. So with all that, I just wanted to make sure everybody knew where we were at in space and time. What are you hearing from the experts so far in their early analysis?
So what I'm hearing from experts is that they weren't really surprised. One of our more frequent commenters, Richard Andriano from Ballard Spar, I always enjoy getting comments from Rich. He said back in 2012, he was sitting listening to some oral arguments before the Supreme Court, and one of the justices made a statement, and he just said, Chevron's dead. Well, here we are 10, 12 years later, and he called it. So yeah, a lot of the experts are saying this has been a long time coming, but yeah, they're also saying it's hard to say what's going to happen now. And I think we're all in a wait and see pattern. We want to see what the arguments are going to start looking like. I think we're kind of waiting for those aggressive attorneys, actually, that we were just talking about, who are going to start making these arguments. And we're going to want to see how the judiciary is treating them. What's holding water? What isn't? I went back and looked at the opinion, like actually read the opinion, not just the syllabus. No, I did not read the whole thing. I am not a superwoman. But the opinion acknowledged that the judiciary needs to seek aid from the agency interpretation, which is something that the dissent very much focused on, was that, look, these agencies are the subject matter experts, and Congress knows that when they legislate. They intend that to happen because they have to delegate these, I don't want to say it's minutia because it runs our industry, but in the grand scheme of running an entire country, it's minutia to them. They have to move on to the next big deal. So,
well, and you were mentioning earlier the potential for, say, circuit splits and
that's what
potential court shopping. And because again, I know there are a lot of business people out there going, okay, we finally, with this ruling, we finally stand a chance in at least having an equal playing field when we, to your earlier point, have an issue with our regulator that needs resolved. And that's fine. And it's also fine, I think, to say, okay, yeah, we might have some court splits if it's, kind of a small issue. But, and just to use an example, I'm not saying these are things that are in danger of being redefined. But if you're, say, a national lender, and what constitutes a qualified mortgage or an interest rate or an APR is determined in the Sixth Circuit to be one set of items, and in the Fifth Circuit, an entirely different set of items, I don't know how you do national lending or a national title and settlement company with the potential for real market deviations in different areas of the country.
Well, it sounds like you're going to have a much larger legal department to me, because you're going to have attorneys that need to who are able to practice in those states and in those districts, but also are keeping up with all of these different circuit changes. And eventually, if there's enough circuit split, what do you know? We have another rule in front of the Supreme Court whose, I'm sorry, docket is still quite large and continues to grow. Mm-hmm. And I mean, we saw an issue with this particular term where they couldn't really solve their opinions by the end of the term. They had to continue on, and it feels unstable to me almost. There's something else coming.
Yeah, well, and so while it's easy to think, okay, great, I'm going to have more equal footing with my regulator when we're in dispute or disagreement, that can feel really good from an empowerment perspective. But then when you come back and say exactly the other, okay, so what do you need then to compete with them and prove you're right or they're wrong in court? You still need the lawyers, right? You're still going to be doing battle. It's just the where.
It's just the where and how often. You're going to be doing more and more battles. And let's flip it on its head a little bit. We just talked about, industry challenging the agency. An agency bringing an enforcement action may do it more so deliberately of, I'm going to bring this enforcement action in the Ninth Circuit against this particular lender who might not be the best example of what I'm trying to do, but I want to get my interpretation on the record and supported by one of the circuits. So you have that shopping on both sides.
Both sides, yeah.
And how fair is that to those industries who may be operating in more progressive or more conservative circuits?
Yeah, it could be, and this is all and again, we don't have the answers today, and I'm not trying to scare everybody to death today, but, I saw some initial reaction from industry late last week and early this week of just, yay, Chevron's dead, yay, free the people, right? Free. And I'm like, what? The other side of that coin, though, is it could be less complicated. It could be clearer. We could get more bright line guidance that's easier to follow. We could get fewer regulation by enforcement type things that have been a bee in businesses bonnet for a long time. And it could be like the Wild West gunfight out in the courts too. I don't think we know.
Right. Absolutely, Mary. And as you've said, we've said a couple of times, it's a little too early to tell. So I don't, we shouldn't be chicken littles. The sky is not falling, but this is also not a free at last moment. So
somewhere in between.
Exactly. It's somewhere in between.
And we have to figure it out. And then in thinking about this, and if it's, I know it's too early to predict, and it's probably all going to be foolish even later to try to predict the outflows of Chevron. But then I've been adding to it a couple of other opinions we got here at the end of this term that I'm still trying to really understand how the three daisy chain together. And that is the SEC opinion we got on Thursday.
Jarksky?
Yep. Yes. I don't pronounce that name right either, but
I don't either.
And then we got Chevron on Friday. And then on Monday, we got the Corner Post case. And I think you really have to look at all three of these in tandem. And I know very few of our audience are going to be down that deep in them. So should we give the high level of those other two cases real quick?
I can do my best because I'm going to be honest. I'm in the process of looking at that myself.
Sure, we all are.
You kind of just described what my holiday weekend plans are.
Yeah.
So with Jarksky and versus the Securities and Exchange Commission, we are getting a little bit into the weeds about administrative law that some people might not be aware. In each agency that has, that enforces and regulates an industry, there is an adjudicative proceeding. It's removed from the courts. It's entirely internal. And the reason behind it is kind of to meter how many cases go to the complaint phase and how many cases go into the court. It's an opportunity for the agencies and the industry, the agencies and whoever's in trouble, to have a conversation and come to a resolution before anything ever gets put on the public record. Mm-hmm. The agencies will still always say they have an enforcement action, but that's to their own device. It's not, the documents, the proceedings don't go on the record. What Jarksky determined, what the court decided, was that those internal adjudicative proceedings were an unconstitutional violation of the Seventh Amendment right to a jury trial when the SEC was bringing civil penalties. So in other words, the administrative law judge, who has the same kind of protections and the same kind of role as a judge in a normal court, is restricted now.
Because it felt, the viewpoint from business was, this feels a little insular. So who do I see about when I disagree with you? Oh, it's your judge, right? I mean, the administrative law judge. And this, people have had issues about administrative law judges. Some people have issues all the way out to bankruptcy judges, by the way, thinking that there shouldn't be. So we won't get.
Yeah, no, that's way in the weeds, Mary.
But it's important. It's important to couple that with, okay, not only are we not deferring to the agency anymore, then the SEC case says what?
The SEC case says that basically you have a right to a jury trial during these adjudicated proceedings, which I don't know if those people who, have had to go through jury selection, that adds a whole new other, step to everything, slows down the process even more. Again, I haven't read this whole opinion yet, so I don't know if that means that the agencies have to start doing jury calls, and I'm not quite sure what that would look like, a jury of peers in an agency adjudication, or that means that, again, the agency is going to have to start bringing these complaints in the courts, which, again, puts everything on the record, every motion, every document that you would ostensibly put in for a court case is now going to be on the public record, which I know I keep harping on that, but that's because in the adjudication proceedings, those documents aren't made public.
Yeah. So from a business perspective, that can feel like, okay, we're going to have this out in the light of day now. When I'm accused, it's going to be out in the light of day. It's not going to be in the smoky backfilled rooms and all that. So I agree with you. And that's probably as far as we should or want to go on that one today. Then when you add Monday from Corner Post, can you summarize for everybody what that outcome was?
Okay, so that outcome, and that one is talking about when the statute of limitations starts to begin for an administrative procedure challenge or violation, when the regulator says the APA has been violated, when the injury occurs. I'm still trying to process what that means for the administrative estate, but that case combined with the ALJ determination, administrative law judge, sorry for using an acronym there, and Chevron, there's some significant limitations to the executive branch that just happened over the last week and a half that, again, taken to each separately, it's like, oh, okay. But then when you start adding them up, it's going to compound. I mean, what's the phrase? Synchronicity?
Mm-hmm.
Synchronicity. All of these are going to come together to create a bigger impact that we might not be anticipating yet.
Right. And I'm with you. I am just starting to really digest this Corner Post case, but here's what I've taken from it so far. And I don't have a law degree, but is that, before you had kind of 6 years from the final rule being issued to the time that there was a 6-year period of which injury could be, and after that you're out of luck. Like the agency wins roughly. God, attorneys are dropping dead right now listening to this, and I'm sorry, I'm a hack. But what has changed now is that you have 6 years from the discovery of your injury, which, okay, that sounds interesting. But one of the oddities for me about the Corner Post case was the entity, the plaintiff, that was an entity that was formed after the rule was well into effect. They were not in the business. This entity was formed. They began undertaking this business and then got injured by the rule and went, hey, this rule has injured me now and I need some redress. And that one, I think when you understand that they didn't exist when the rule was put in place, and if I'm botching this, everybody, I'm sorry, but then they discovered injury after they got into the business and said, who do I see about that? It's no longer sit down and go away. This is the reg. It's up for debate now. And I think when you combine all three of those things could get real spicy in our courts.
I think you're pretty accurate on that, Mary. It's pretty spot on. Anybody who thinks regulatory law is a snooze fest is absolutely incorrect. This is the kind of stuff that's really going to change how our agencies operate, and it's going to have a national effect. It's going to have that trickle-down effect. But yeah.
There's some things in here that are going to be good for business. Again, I can feel our business people just cheering like, oh, I can maybe have equal footing now with the boot that's been on my neck for those that, and, right. And there have been some overreaches. There have, if we're being fair. To now, is everything up for grabs? And again, I know the Supreme Court did a solid attempt at saying reliance and stare decisis, let's not relitigate everything. I just don't know that we're going to I don't know that there's a mechanism to make that true. And I don't know if we have the restraint or even the desire to make that true. And that's where I think it could get real interesting over the next, I mean, years. Certainly we're going to be sorting this.
Years. Again, I haven't been in the, I'm actually going to say I haven't been in the industry for long enough. I know that there's going to be a lot of people who, this has been their career, who might laugh at this, but I'm thinking maybe 5 years, we're going to start getting what those theories are. We're going to have those schools of thought. And then in 10 years, we're going to start seeing which ones are kind of, what's the horse ahead in the race?
Yeah.
Does that make sense?
It does. It does. Well, I know that this is so early on in probably a decade-long situation. We are literally on our third business day after this. So I know you're not going to have all the answers, and we don't even know all the questions yet. But what I appreciate two things. You're being willing to come on and help people understand this new landscape that literally a week ago today did not look anything like this. And we're trying to understand how the jigsaw pieces fit together. And the other thing I know, and I can tell by the reporting that you've already done in RESPA News with your experts, is that you're going to keep everybody abreast of these developments, and we're going to help them tool. We have to help them tool, but first we have to understand what the law is, cover where the law is going, and then be there on the other side to help people understand how to operationalize and implement the things that come out of it. So yeah, it's going to be a long, strange trip, I think. But I can tell all the listeners who don't yet know Elizabeth, who are going to want to know her much better after this, because she's going to be the one keeping us all informed. Everybody's got to pay attention and be on their toes. And oh my gosh, whatever questions industry has, we need to know how to help answer them. But this is going to have the potential to change, maybe not everything, but a lot of things.
Absolutely. And I guess one of my parting ideas of what I'd give to anybody who's listening to this podcast is, crap, I just had it and it was beautiful.
It's okay. Let that little sheep come back in, and then we'll start again from the top.
I got it. I have it. So
start with piece of advice.
Yeah. So one piece of advice that I would really give this industry is, yes, this is a little more freedom, so to speak, but freedom comes with responsibility. We see that in our legislature. We see that, in voting in elections, you have a responsibility to be educated and you have a responsibility to communicate. We can't expect our regulators to understand what the issues really are and to create effective rules without the industry, who are the subject matter experts in our viewpoint, telling them how their theory is being executed in practice.
Yeah.
So that's what I would say, is to keep in mind. Freedom is great, but it also imparts more responsibility on those who have it.
I couldn't have summed it up any better, Elizabeth. That's great. And I know we're going to be working to death to help them stay educated, informed in that responsibility. Other sources are too, but thanks for your commitment up front to be down there in the weeds doing the hard work for everybody so they know what to do.
Yep, absolutely. Anytime I can offer some perspective or help clear things up, you know where to find me.
I will be finding you. Thanks for joining today.
Yep, not a problem.
Thanks again, Elizabeth, for helping us to begin to understand the potential for deep and far-reaching impacts to the rules of the road for our industry. And although sitting here today, it's impossible to predict exactly what will change, one thing is perfectly clear. There are big changes ahead. So thanks for your commitment to helping everybody stay informed and current as the marketplace begins to understand and adapt to the windy roads ahead. So everyone, our RESPA News publication is where all the updates will be reported out so you can adapt and stay compliant no matter how the course ahead unfolds. Elizabeth's email is linked in today's show notes. If you have thoughts or questions, I know she'd love to hear from you. And thank you for joining us today. We'll keep bringing the conversations with the professionals you need to help guide you and help you continue to successfully hold your keys to real estate. So until next time, I'm Mary Schuster for October Research, where knowledge is the competitive advantage.